with another moment which seems to invite us all to rub our eyes and check that what we're seeing and hearing really is what is happening. It is, of course, the Senator Natashas Akpoti-Uduaghan rumble in that political jungle that is the Nigerian Senate, a rumble that is, well, still rumbling on. And now it's ignited a ferocious legal and political debate among senior advocates of Nigeria, those senior lawyers who are recognized for their outstanding advocacy skills and high level of legal expertise. It's raised grappling questions about the legality of suspending legislators, about the Nigerian constitution, and about the extent and limits of the powers of the leaders of the national and state assemblies. The overwhelming conclusion from top lawyers such as Femi Falana and Jibrin Samuel Okutepa, to mention just two, is that there are absolutely no legal grounds for Senator Uduaghan's suspension. They argue that the Nigerian courts have consistently and definitively pronounced on the illegality of the suspension of members of legislative houses in Nigeria, and they call on the Senate to immediately lift Senator Uduaghan's suspension. But in a chamber which some allege has long had a culture of officially sanctioned impunity, what will it take to get them to heed? Well, for his assessment, I'm joined now in the studio by Jibrin Samuel Okutepa, who's a senior advocate of Nigeria and a prolific advocate of legislative and judicial reform. Thank you very much indeed for coming in.
Thank you, Charles, for consistently putting pressure on me to be here.
I like that. And thank you for conceding this time to actually be here.
Yes.
Because what you have to say in this particular context is of tremendous value to our viewers and to Nigerians. Let's just be absolutely clear on this. What does the law say about the suspension of a member of a legislative assembly? Can the legislative house suspend a member of that house if the member is deemed to have violated the rules of the house?
Well, Charles, the answer of no is so notorious that even the deaf by now should have known that the power to suspend a member of parliament have consistently been pronounced upon by our superior courts of records, including the Supreme Court of Nigeria, the Apex Court. I have the privilege, for instance, to have stood in for a member of Kogi State House of Assembly who was suspended for moving a motion that the then government was unable to pay salary for his people. He was threatened with suspension. He went to court, and indeed to show the audacity of arrogance of a violation of our laws, the parliament then suspended him from his legislative duties and stopped his salaries and allowances. And so we were angry. We went to court. My Lord, the Honorable Justice Josiah Majebi J, as he then was, now Chief Judge of Kogi State, saw his way clear and declared that no member of the legislative houses of assembly can be suspended or restricted from performing his legislative duty on account of internal rules of parliament. The Kogi State House of Assembly was not satisfied with that decision, appealed to the Court of Appeal. The Court of Appeal said that the procedure that I employed in commencing the action, which was originating in someone, was wrong, and so remitted the case back to the Chief Judge of Kogi State for the matter to be commenced by writ of summons. I was not satisfied, my client was not satisfied, and so we approached the Supreme Court. And the Supreme Court, in the case of Elder Friday Sani versus Kogi State House of Assembly, reported in 2019, Law Pavilion Electronic Report, came down heavily and made a pronouncement. And my Lord, the Honorable Justice Walter Onoge, JSC then, as he then was, later CJN, now retired, was profound in his view, and my Lord held, and I quote, "And I am of the considered view that this appeal succeeds in part and order as follows: that the judgment of the court below be and is hereby set aside, that the judgment of the trial court be and is hereby restored and affirmed, that the respondent be and are hereby ordered to pay the appellant all his salaries and allowances, emoluments and money due to him, and to allow him to resume his legislative duties forthwith," unquote.
But is that a general sort of precedent rule, or is it specific to that particular
No,
case?
the relief we sought in that case was that the respondent, which is the House of Assembly, had no right to suspend or
under any circumstance.
On any circumstance.
Right.
It was granted. But before we miss the reasons why I'm so ashamed of the circumstances we found ourselves. Senator Natashas Akpoti was accused of a breach of the rules of the Senate. Not that her petition was attended to, found to be unmeritorious. And so as of today, Charles, you and I, and all Nigerians, are in the dark as to whether or not Senator Natashas Akpoti's allegations was right or wrong. But that is beside the point. Now, Natashas Akpoti was said to have breached the rules of the Senate. Now, the Senate of the Federal Republic of Nigeria, in dealing with Senator Natashas Akpoti, committed grievous constitutional sacrilege when, first, the Senate President, who is the accused person, presided over the proceeding in which Senator Natashas Akpoti laid her petition. Two, the Senate President was the one that said, "Is there any impediment for the reception of this petition?" And the answer that I heard was saying no. The same Senate President was the one that later on presided over the proceeding in which the petition that was laid was found to be, did not follow the procedure for laying of petition, that it was signed by Senator Natashas Akpoti. It should have been signed by another senator. The same Senator Akpabios, the President of the Senate of the Federal Republic of Nigeria, was the one that referred the conduct of Senator Natashas Akpoti to the Ethics and Privileges Committee of the of the Senate of the Federal Republic of Nigeria. The same Senator Gov Sim Fubara was the person that appointed the chairman of the Ethics Committee of the House of the Senate of the Federal Republic of Nigeria. After all said and done, the same Ethics and Privileges of the Senate of the Federal Republic of Nigeria brought in the report. Senator Gov Sim Fubara was the presiding officer that determined the fate and the viability of the report. He was the one that reeled out and hit the gavel that Senator Natashas Akpoti be suspended for 6 months. Then in the second part of the motion, which I think you had, everybody had, was whether or not in the punishment reeled out by the person who was accused, the person who was the presiding officer, the person who was the judge, and the person to whom the report was sent to, was whether or not Senator Natashas Akpoti was to have, before she resumed her legislative duty, put in a written apology to the... I heard with my ears, and I'm sure Nigerians heard, that the nay was higher than the I, but the Senate President said the ayes have it. Why did I say so? That that procedure was more grievous than the allegation against Senator Natashas Akpoti. Section 36, subsection 1 of the 1999 Constitution, which is the ground norm of Nigeria, says that in the determination of one's civil rights and obligation, the person shall be entitled to fair hearing within a reasonable time by a court or tribunal constituted in such a manner so as to ensure its impartiality. In other words, Nigeria operates the rule of law, and under the rule of law, there are twin pillars of that law. The principles of nemo jude in casu sua. You can't be a judge in your own cause. The principle that you cannot condemn a person on heart holding utterance party. There is also a principle of law which was propounded by my Lord late Justice Philip Nnemeka, that when in the governor in the governor of Lagos State by Chief Emeka Odumegwu, that where parties have turned over their dispute to a court, none of the parties should do anything to undermine the authority of the court. I am aware that in the procedure leading to the sending Senator Natashas to the Ethics Committee and in the procedure of the House, that National Assembly took judicial notice of the point that Senator Natashas had filed a litigation in court.
Right.
The same National Assembly or the Senate of the Federal Republic of Nigeria refused to acknowledge the order of the Federal High Court stopping the Ethics and Privileges Committee from proceeding with the matter. In other words, for you to see how the institution that's supposed to be the institution that makes law for us desecrated the Nigerian Constitution on primordial partisan interest, they ignore the court order. And the principles of law of considerable antiquity that I know is that no person, however highly placed, including the President of the Federal Republic of Nigeria, can sit under the comfort of his office and say that an order of court duly issued by a court is without jurisdiction. You can't say so. Right. Well, if you decide to say so, right, then it's an invitation to chaos and anarchy.
Let me ask you for clarification on that point, because you are a senior advocate of Nigeria and you speak from an informed position. You're well accomplished as a legal eagle in this country. Let's be ineluctably clear. Was the Senate within its rights to proceed regardless of that Federal High Court restraining order? Because their argument is that under Section 60 of the Constitution, they ought to be able to operate and define their own rules and procedures.
I will answer your question by asking a question. If they had respect for pendency of a case at one breath, what suddenly changed when it came to punishing Senator Natashas that they have no respect for pending matter? The rules of the Senate that I know is that once there is a pending matter in court, they should not deliberate on the matter. The question you should ask yourself, and they should answer, is that was there a court order? Were they served? They acknowledge that they were served. Look, Charles, I'm very serious about this matter. The Senate President is a lawyer. The chairman of the Ethics and Privileges Committee is a lawyer. There are seasoned lawyers in that house. The duty we owe is the duty to demonstrate civility and respect and fidelity to the rules of law and the code of conduct for the legal profession. Whether a lawyer is a politician or is acting in court is bound by the rules of professional conduct. So when our conduct suggests that we undermine an institution, the judicial institution, to the extent that we can choose and pick which pending litigation we should respect, which one not to respect, especially when done by those who have been called to the bar, then when market men and women chose to desecrate the court of the land, what will you say? So as a minister in the temple of justice, therefore, more responsibility is expected of us.
Yeah.
My worry and my quarrel is not whether or not Natashas is right or is wrong, Senate President is right or is wrong. For every allegation, the investigative apparatus for that allegation must not itself be a person that is with vested interest, with a propensity and temptation for revenge. That's why Chief Justice Best said that justice must not only be done, but be manifestly be seen to have been done. Question you should ask yourself is, will the right-thinking member of the society go away, believing that the petition of Senator Natashas that was summarily dismissed was fairly treated, given that the presiding officer was the person against whom the allegation was made?
Well, let me clarify some points here, because their argument is that the issue before them, although she handed in a petition about the sexual harassment issue, but that the issue before them was not actually about sexual harassment, but about her persistent misconduct and disregard for Senate rules and gross indiscipline. They say, let me just make the point, they say she refused to adhere to the sitting arrangement.
Yes.
Do you believe that this was why she was suspended, or do you share the conviction of those who insist that she was suspended because of her sexual harassment allegations against the Senate president? Because those two issues seem to be overlapping, and the senator are very keen to separate them.
I am here to speak about the allegations against Senator Natashas of her insubordination, so to speak, in not accepting the sitting arrangement and speaking when not recognized. Who accused her of doing so? The Senate president. Who referred her to the ethics committee of the Senate president? Did Senator Natashas go to court to say, I will not have a fair hearing, putting it in a more African proverb, that I am going to a garden of chicken and I cockroach, I will not be expecting to have fair hearing. Because in the garden of chicken, cockroach cannot be expected to have fair hearing. So she, reasonably entertaining the fear that she will not be properly treated, she rushed to an institution created by Section 6 of the Constitution that is a specialist in adjudication with impartiality as the attributes of the judges sitting there. Then you say, no, I will deal with you. Because when a man is accused of wrongdoing, it has gone outside the realm of the rules of the Senate. It has now brought the right to fair hearing, which is in chapter 4 of the Nigerian Constitution. Right. And even the Almighty God did not condemn Adam on earth. Adam, where art thou? Have thou eaten of the fruit whereof I say thou shalt not eat? Adam had a defense. The woman you gave me, I was resting on my own. You gave me this woman. He asked the woman. The woman said snake. He heard them before passing judgment. So if God that is all-knowing could give fair hearing in the Garden of Eden, then what do you say about women?
Okay, well, we're almost out of time, and I want to just come in here briefly and ask you a couple more questions. So based on what you've now told us, it is legally safe to conclude that the suspension of Senator Natashas Uduaghan is illegal?
I have no power to conclude, but it appears to be so.
Right.
Because the power to conclude that it is illegal, but I can say confidently that based on what we call stare decisis, precedents of our superior courts, is likely to come to be the outcome.
Right. People like yourself, people like Femi Falana and others have called for the lifting of the suspension without delay. What happens if the Senate refuses to do so?
Natashas should go to court. Because, let me tell you, Charles, the reason why we do what we do in Nigeria and appear to get away with, like I put up in my write-up, is that there is not that there are want of precedents, but the power that believes, and wrongly too in my view, that they are above the law of the land. They can do anything and there are no consequences. Otherwise, if Nigeria is a country where consequences are visited on people, everyone, particularly those who have the legal training that fail to properly guide the Senate of the Federal Republic, that what you are about doing will bring a boomerang and embarrassing effect to the nation, would have advised them and not doing so. But what do I know? Because you are accusing a member of parliament of an infinitesimal breach of your rules that is just like a subsidiary legislation, and you have now, in a geometrical proportion, violated violently the provisions of Nigerian constitution that gives adjudication and judicial power to the court, and the fact that in the determination of a dispute, even in administrative inquiry, you must respect the rule of law. Have we? Look, let me tell you that
very briefly,
the rule of law
is
the bedrock of democracy. But our politicians preach the rule of law, but they practice rule of self-convenience.
Right. As a final question, and very briefly, do you think anything should happen to the ethics committee? I mean, does anything ever happen to people who make the decisions that you feel are wrong?
Make anything to happen? That's why we must begin somewhere. And I think that it's time now, particularly those of us who have a higher calling, whose qualification is just not mere secondary school or its equivalent, who have been admitted to practice law in Nigeria, that our professional association should start holding us responsible. And Nigerians should start holding us responsible. Because if we desecrate the Nigerian constitution, then authoritarianism becomes the real thing. And at the last time I checked the definition of democracy, authoritarianism and despotism were not part of the attribute of democracy.
Indeed.
In democratic setup, the freedom to speak and to be heard undiluted are part of the attribute of democracy. And so if we must not allow our democracy to suffer shipwreck, then it is time for us to respect our constitution.
On that note, I want to thank you very much indeed. You've made the points most forcefully, and we appreciate that. Jibrin Samuel Okutepa is a senior advocate of Nigeria and also a prolific advocate of legislative and judicial reform. Thank you very much indeed.
Thank you, Charles.